Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about novel torts. Cases that should have gone to the Supreme Court of Canada, but didn't. A forestry company in BC sued the BC provincial government on the basis of the fact that they did not agree with the fact that they were not considered for government contracts. They alleged that they were the subject of a blacklist and that the blacklist was illegal. Although there is no law preventing blacklists, nor any law saying that a blacklist is a tort in British Columbia, the company argued that blacklisting corporations and blacklisting companies because government doesn't agree with their activities did constitute tortious behavior, and that a new tort should be created as a result of that conduct to recognize circumstances where this occurred. The court disagreed and refused to find that a legal tort should be created for the activity of blacklisting. The case went to the Supreme Court of Canada and leave was denied. This case raises important issues because blacklisting is something that is becoming more and more of a concern, particularly as a result of movements that some people call things like cancel culture, where people's political or social activities may lead them to be effectively disincluded from consideration for professional opportunities, and whether that disconsideration for professional opportunities amounts to a tort is something that should be considered. It is effectively a way for government to police the private views and activities of citizens that otherwise are protected by charter rights like freedom of expression. And so blacklisting somebody because they engage in conduct that you disagree with, including making requests or criticizing data management, could lead to financial disastrous results for those companies, which would be arguably wrong, particularly depending on the circumstances that led to the so-called blacklisting. And obviously there are concerns about the way in which the digital information age can be used to create blacklists and to essentially stop people from obtaining business or obtaining contracts from government as a result of those blacklists. This case should have been heard by the Supreme Court of Canada to determine not only whether blacklisting itself should amount to a novel tort, but also to revisit the standard that's applied to determine whether a tort should be accepted as a novel tort. The question arose in this case about how much academic literature and commentary about the existence or absence of something as a tort would be required for it to meet the standard necessary to constitute a novel tort. And simply because there is an academic literature about an issue doesn't mean that it's not an issue that affects people that they should have the right to be able to sue on. And the Supreme Court of Canada had the opportunity to make it a little bit more fair for people who can't really dip their toe into the academic discourse necessary to establish a foundation to then bring about a claim for tort, particularly in light of limitation periods that apply in tort litigation. All of this was important issues that should have been visited by the Supreme Court of Canada in this case. And unfortunately, it's going to take another circumstance, potentially of somebody being blacklisted, arguably on the basis of conduct related to criticism of government that is unjustified or unreasonable, that leads to the Supreme Court of Canada ultimately considering whether blacklisting should be included as a novel tort in British Columbia. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.